Okay, welcome everyone. We're going to get started even as the room continues to fill up, as we have over 40 questions to answer tonight, and we want to get to them all if we can. For those of you who don't know me, my name is Rebecca Poole, and I'm CNYC's Director of Membership and Communication. On behalf of CNYC and our speakers tonight, I would like to welcome you to the second installment of our free roundtable series, where we'll answer questions submitted by co-op and condo board members. Before we get going, just a little background on CNYC, the Council of New York Cooperatives and Condominiums. We're a membership organization that provides information, education, such as the class tonight, and advocacy for New York City co-ops and condos. CNYC strives to safeguard the financial stability, way of life, and sense of community sought by cooperative and condominium homeowners such as yourselves. Our efforts have produced multiple victories, including the co-op condo tax abatement, a reduction in the number of drops required for FISP inspections, reverse mortgages, and so far staving off legislation that would control co-op admissions. Our information and education includes e-blasts, an annual housing conference, regular discussion groups for board members, and evening seminars. CNYC is funded almost entirely by member buildings, so we can maintain our independence and focus. If your building is not a current member, we encourage you to join us. Members get to vote at our annual meeting, which will be held in person on April 17th at 6 p.m. at the General Society of Mechanics and Tradesmen at 20 West 44th Street. It's free and open to all shareholders and unit owners. We'll have representatives from the Department of Finance, Department of Buildings, Sustainability, Department of Environmental Protection, New York City Accelerator, and the New York City Council. It's a great opportunity for you to speak with these representatives and discuss any issues you might have with taxes, real estate tax abatements, local law 97, flooding mitigation, FISP, etc. It will definitely beat your trying to call 311. We'll have legislative and regulatory updates, and we'll discuss our plans to tackle the onslaught of compliance legislation and regulation, as well as additional funding for Local Law 97. Obviously, the more people who show up, the bigger statement we can make, the more sway we'll have with City Council, so we urge you to join us. And now for tonight's class, we're pleased to have 6 distinguished speakers that are dedicated to helping co-ops and condos like yours. Bruce Cholst is a partner in Herrick's litigation department, where he focuses his practice on real estate litigation and cooperative and condominium law. Bruce represents cooperative and condominium clients in complex sponsor defect and sponsor arrears litigation, shareholder controversies, commercial and residential non-payment actions, foreclosure suits, vendor claims, and board election disputes. He also counsels clients on corporate and governance issues and negotiates their commercial leases and management contracts. Bruce has served on the New York City Bar Association Subcommittee on Cooperatives and Condominiums, as well as the New York State Bar Association's Cooperative and Condominium Lien Subcommittee. Bruce has also served on 2 different co-op boards for a combined total of 28 years. Ron Gold is a partner of Kagan, Lubic, Lepper, Finkelstein, and Gold. He has over 30 years of experience representing co-ops and condos throughout the New York metropolitan area as general counsel. Ron's experience is rooted in representing tenants associations through the conversion process and beyond once the sponsor surrenders control. Ron is proud to have continuously represented a number of his firm's clients for over 25 years, guiding them as well as newer clients through virtually every imaginable issue facing cooperatives and condominiums today. Ron is regularly called upon to develop innovative strategies for addressing unique problems that his clients face. Jessica Tusing is the Director of Compliance for Argo Real Estate, a Manhattan-based property management firm that oversees approximately 120 residential buildings across the city. Jessica has over 10 years of proven property management experience and is an expert in implementing regulatory compliance procedures. Jessica also serves on the board of the Institute of Real Estate Management, New York, or IREM, and is a member of the Management Council for REBNY, or the Real Estate Board of New York. Sophie Bird is a Senior Vice President, a PNC client executive, and a senior member of the residential real estate team at IMA New York. Sophie specializes in commercial real estate insurance. She partners with property managers, real estate owners, and developers to help identify their exposures and educate them on how to utilize insurance and other means of risk transfer to reduce costs and protect their business. Sophie has been with York, now IMA New York, for her entire career, starting as a college intern before joining the company full-time in 2008. Sophie has earned the CPCU industry designation and graduated with a BA in economics and psychology from Bucknell University. Neil Valsangkar joined York International, now IMA New York, in 2019. He is currently a senior vice president and serves as IMA New York's Director of Claims and Risk Services. In this role, Neil manages a team of claim professionals handling matters arising under all coverage lines, including but not limited to general liability, property, directors and officers, errors and omissions, cyber, crime, and employment practices liability. Neil provides advice to clients on policy wording, defense and settlement strategies, and coverage issues. He also provides recommendations to C-suite level clients in connection with risk mitigation practices, including contractual risk transfer. Finally, our moderator for tonight and CNYC board member, Michael Wolfe. With over 4 decades of dedicated service in the real estate industry, Michael's journey began in 1986 when he embarked on his property management career in Midborough Management, steering its course for nearly 35 years. During his tenure as owner of Midborough Management, Michael was instrumental in implementing and refining best practices that not only optimized operational efficiency, but also significantly enhanced property values for boards and owners alike. His commitment to excellence extended to prioritizing the resident experience, ensuring that every interaction reflected a dedication to quality and service. Michael also assumes pivotal roles such as the chair of the Real Estate Board of New York's Residential Management Council and as a board member of the Council of New York Cooperatives and Condominiums. Thank you, everyone. And Michael, the floor is yours.
Thank you, Rebecca, and thank you for the panelists who've joined us. You will find through our series that we have really talented panelists, as we do this evening. We're fortunate to have all of your questions in advance, and we all took the time to really focus on them and be able to give you the answers that requested based on what you have submitted. So we have legal questions, we have compliance questions, we have insurance questions, we have management questions, and let's get right to it. So you're a building and you want to perform work on the exterior of your building, or any work that requires an access agreement, neighboring building, and your neighbor does not want to sign. They don't want to be cooperative. They don't want to play nice in the sandbox, and it's stopping you from doing your work. Maybe you have a sidewalk shed up and you're spending money on mobilization. And, you know, for whatever reason, either they won't sign it, they want money to sign it, they want too much money to sign it. And there's a question about what do you do if they don't sign it, is part one. Part two is, how long will it take if we, commence a court action? In this particular case, the author mentioned that they've been negotiating for 8 months, probably 8 months too long. So, and also, what should we look at the access agreement? And how it'll impact use at the building with people with terraces, which the management side will touch on. So we have Ron and we have Bruce on the legal side, and Sophie and Neil could certainly opine on the insurance side. Let's start with part one of this. Uncooperative neighbor negotiating for 8 months. What do we do, Ron and Bruce?
I think the most important thing is to start early, even in your project planning. I recommend normally with my clients that when they're sitting down with the engineer to do their FISP and their studies and filings, that's just about the same time when they know they're going to do this work that they should start the process. Don't wait until you're about to start the work, you got your final approvals by the building department to start the process, because it is a long process, even if you are negotiating the agreements in good faith. It also a lot depends on whether or not the people next door are another co-op or a condo, because there's a lot of times where you can cut through all this by everybody understanding it's a mutual relationship, because when one day you're going to need the access and the next year it could be the other guy. The problems come up from my experience where you have somebody next door who is in a different position than you are as a co-op or condo, usually another residential property, whether it be a brownstone or something that's lower than yours, has backyards or other things that they want to protect. So once you get into the situation of negotiating, you have to go through the process. But again, it has to be good faith. There is a section of the real property and proceedings law in New York that demands that once you make a call to the other side and try in good faith to get an agreement on access, it gives the person who's needs the access the ability to go to court and file an action. And in that action, the court is going to be in a position to determine the terms rather than the parties of the access agreement, which will cover a number of things that you would normally put in your own agreements if you were doing one that you're freely negotiating. Things like what type of protection is necessary, how long it's going to be there, the scope of the work that you have to exchange and make sure that you get copies of if you're on one side or the other side of that equation of the negotiations. And you want to make sure that your building is, if you're the person who needs the access from the other guy, you got to expect that the other side is going to want protection. And that sometimes is the easy part. The part is when, as mentioned by Michael, when they want an unreasonable amount for, quote, the use of their property or interference with the use of the property. And that's when you get into the biggest fights. Most of the time, it's not about the technical terms, the insurance requirements to protect their property and make sure they're covered for damage between your building's insurance and your contractor's insurance and review. That all has to go through, as I'm sure that Neil and Sophie can talk to. Jessica, I'm sure, has been through that many times as well, and has to be reviewed by your building's insurance as well as the other building's insurance carrier and or people. But it really comes down to is how much is the money that somebody demands for allowing you to use their property or interfere with the use of their property. When these things started many years ago, it was basically if you were doing something that was like local law 11 required by law, there was very little that where the courts were awarding or that people could bargain for. But then the courts started expanding that and instead of having, okay, if it's required by law, it's one thing, but if you're doing a new development, which is sort of voluntary, they would make sure that the developer had to pay more money to the person, but that got expanded. And now we're seeing more and more of the courts award for loss of use of terraces, balconies, back courtyards, and other things. Where the person who needs the access is interfering with the use, and therefore the adjoining landowner, for himself or for his tenants, wants some type of compensation.
So Ron, if we go to court and we try to shake hands, we buy them chocolates, we buy them whatever it is, right? We're trying to be nice with the neighbor. What's our under/over on the court proceeding, realistically?
It's you're entitled by law. It's one of those things where it's under both the administrative code and the state real property and proceedings law, where the neighbor has to give you access. The question is on what terms. And the one thing that I've learned over the years, and I'm sure Bruce has been through this many times also, the courts do not like the person who's trying to hold it up in unreasonable ways. They want, and they think that the standard is there good faith? And the statute actually, starts you off by saying you have to make a demand and then it has to be rejected by the other party and it has to be basically unreasonable and they can't not respond and things like that. So if you, by the time you go through that stalemate and you're going into court, you sort of have the white hat in most cases. And the courts are going to say, Mr. Objector, you better have some good reasons. And the person who is objecting, if they haven't made a deal or making certain things, if the things they demanded in part of the agreement were somewhat reasonable, commercially reasonable, not trying to take advantage of the situation, the balance and the prognosis in court is very good. The problem is that courts and litigation are very expensive. There is nothing, that people hate worse than having to wait and wait and wait, because by the time you go back and forth just with the judges, even on unopposed stuff, takes you forever in the courts lately. So obviously you'd like to avoid going to court if you can, but if you've been acting in good faith and you haven't been unreasonable in your demands on either side of the table, that party is going to do well. But the courts have total discretion as to what these terms will be, including reimbursing the professional costs and other expenses, so that if you've hired an engineer if you're faced with a request for access and your building hired an engineer and a lawyer to discuss these things, et cetera, and if you have to go to court and they found that you were unreasonable, well, the court can order the party that's the loser in the litigation, basically, to cover the expenses of that litigation, besides the expenses and protections and insurance and professional fees for engineering services to review the plans of the other side to make sure the protections are adequate and up to code, et cetera. So prognosis is good again, but the one who shows the good faith is going to do the best.
So Sophie and Neil, what things or what parts of the access agreement, that are focused on insurance, do you see it getting rejected by one party, right? Because it's not adequate or has exclusions, things like that. Certainly none of the buildings that you write, but certainly for other people, maybe, put up some of the things that people should be aware of today to make corrections. And we'll talk about insurance in greater detail, but specifically on these access agreements.
Sure. I'll say, it's pretty common that the building you're looking to gain access to, they're going to want you to provide them with additional insured status under your policy. They're going to want to see certificates of insurance and sometimes endorsements to your policy evidencing that. And so just know that your insurance carrier very likely is not going to issue that endorsement or extend that additional insured status until they've seen that your general contractor is doing it as well, and that their coverage is going to apply on a primary basis. So they want to see proof of your general contractor's insurance policies, and then the contract that you've signed with them as well. And in that contract, they want to see that your GC is not only providing you and your managing agent with an additional insured status, but also to the building that you're gaining access to. So I'd say, before you go to your broker and ask for that additional insured endorsement for the neighboring building, have all your ducks in a row and present them with the access agreement, as well as the contract with your general contractor and their insurance policies. That'll make the process go much faster.
Yeah, and I would say in terms of where we get sticking points, it's when we've begun to do diligence on the contractor's policies and they have exclusions or endorsements that might preclude a labor law claim or work from a certain height or an injury to an employee, things like that, where the other carrier could point to saying, while thank you for providing us with this policy, it's not worth the financial, there's not worth the paper that's written on if an injury occurs.
It's also very important as part of that insurance equation that when you're dealing with indemnities and having involved your contractor, the policies and additional insurance, it requires that there's a written agreement between the parties who's indemnifying the other person, et cetera. So in that, remember I mentioned in the early part that you got to bring your contractor on board early and you go to the other side. One of the other things, whether you're in negotiations and put it in the agreement or whether you have a court-ordered access agreement, you have to have a provision, like let's say you do have an access agreement, you have to make sure also that your contractor is going to have a rider to that or be part of that agreement where he agrees to be responsible for damage he does to the other guy's property or to your property and will indemnify. And that goes back to the point of making sure that when you do your contract with your own contractor, you say you will have to provide this and sign an access agreement and not refuse, because that will hold you up. But that's the key to making your insurance work, because without the written agreement for indemnity, there's going to be something that's going to put you out, especially on labor law claims for an injured worker.
So we didn't even start the work yet, right? So we have all these, speed bumps, and really depend on cooperation. Now, look, not all of them go this route. Most buildings have good insurance coverage, they hire the right contractor, and they have neighbors that are cooperative. But the ones that aren't, somebody they had asked about the court proceeding, and they're negotiating for 8 months already. So you're going to be a year in before you even start your work. Sophie, you wanted to add something? I wasn't sure.
I was just gonna add to that point, a lot of contractors' policies unfortunately have exclusions in them. So the earlier you bring your broker into the process, even including them in the vetting process before you've decided on a contractor and signed a contract, the better. Have your broker fully vet their policies, make sure none of those exclusions are lurking there that will cause issues further down the line.
Excellent. Moving right along, Local Law 97. Webinars, discussions, panic, fear, expenses, right? We've spent every building that's in the classification required to do something to avoid a penalty. And look, we all want cleaner air. But in this particular case, Bruce, the writer talked about, or actually mentioned, a building that's below 25,000 square feet. So they are not participating in a possible penalty and changes to the building yet. And the yet is their concern. That, is there a chance this changes and it'll include buildings that are of a smaller size? And will they face liability if they don't comply and check their square footage? Now, let's talk a little bit about two things. Number one is there a chance it'll change? Number two is, do they need to go get remeasured, or where are they getting the square footage from?
Well, one of the things I noticed in the writer's question is that he says his building has a footprint of, quote, around 24,500 square feet. The law is very clear. The cutoff is 25,000 square feet. This writer is not exactly sure of, with precision, what his square footage is. And I think it certainly behooves him to find out with precision. I think he should hire an architect to do the computation and then issue a letter, an opinion under seal, which means that the architect is putting his license behind his opinion, so that the writer would have recourse in case the calculation is off. So that would be a very good defense against liability. However, to answer your question, Michael, I think it's more likely, I'm not sure the law is going to change, that the city, I haven't heard anything about the city's lowering its threshold from 25,000 square feet, but I can certainly see where the city might be sending around auditors to check square footage and might be adding to the buildings list of those buildings which are required to comply with Local Law 97 by making sure that buildings that are around, quote unquote, 24,500 square feet are not covered. So I think it behooves this writer to find, to ascertain what the precise square footage is, and to make sure that he is not compliant. And if he is compliant, then take steps to prepare immediately for compliance with Local Law 97, whether or not he's on the buildings list at the moment.
New York City buildings, houses of worship are exempt, among others, from this. And the same way Bruce mentions about getting possibly measured to understand what your square footage is, they're probably pulling off Department of Finance's role. Now, if you're just above 25,000 square feet, maybe that's also important to get checked. But there is discussion about including buildings that are a smaller footprint. So let's all realize that we need to be energy efficient, maybe not to the, we should be at the level of the buildings that may face penalties, but we should talk about electrification, green air, get an energy audit, regardless of your size. I think we all want to participate in cleaner air. So we'll leave that up to you and the professionals that you engage to look at your building and what changes you'd have to make. And the other thing you should do is just look at what your emissions are, right? What is the company that you engage? If you haven't, please do so, and see what your carbon emissions are per square foot, and that'll give you an indication of where your building stands, regardless of your size. Not every building has a problem, but many do, and they're big problems. On lead paint. So there's been some changes in lead paint, Jessica, about testing, and obviously, a rental, the owner of the building is responsible for paint. A co-op condo, that paint is the co-op condo owner. There's certain common hallways as well, but it seems that every 6 months, every year, the laws are getting tougher and tougher. So what's going on out there now?
Recently, local law 111 has mandated that the common areas of buildings built before 1960 must be tested and by August 1st of 2025, which is the same deadline for local law 31, which is X-ray testing rental units. So there's still some clarification that we need to obtain from the city, but those buildings before 1960 should be prepared for extensive testing and possible repairs to their common areas.
So we're waiting for the official rulemaking on this, but this could be very costly for a lot of buildings.
Yes, because if you find, so you would have to treat any deficiencies found the same way you would find deficiencies in apartments. So high friction surfaces such as doors and windows, even cabinet doors and kitchens, they have to be abated by a licensed abatement company. And then you have to retest to make sure that there's no lead in those areas. They can't be covered with paint. They actually have to be removed and replaced. So that could be similar to the common areas as well.
Thank you for that. Another topic that arose was about doormats. So some buildings have doormats in front of their doors. Some do not have doormats. Some are lucky enough to have them all match. Some of them never match. Some of them are not aesthetically pleasing. What's going on in the landscape about violations and things like that with respect to doormats?
Well, it depends on the inspector that shows up at your building. There's a frequently asked questions on the FDNY website that addresses this. And they said the fire department discourages the use of doormats in apartment buildings and hallways because they find that they are combustible material, not flame-proofed, and they're a potential tripping hazard. So I'm sure the insurance companies can also talk to about the liability with that if there was an evacuation in the building, but it is not recommended to have any type of doormat or items in the hallway for those reasons.
That even kind of expands to when you have a stairwell with garbage cans and it kind of impedes, egress.
Right.
Okay. Moving to Local Law 11, FISP, and reporting. And what is your due date? So your filing reports or requirements are based on the last digit of your block number. So you have a lot and block for each building. And the city, years ago, all the buildings were filing at the same time. It was just absolute madness, right? Number one is everyone filing at the same time is problematic for the city. Number two is buildings all doing work at the same time was problematic for vendors, for pricing, sidewalk sheds, all the above. So the city broke it down into 3 cycles, 3 5-year cycles. So a group of buildings are going an A, B, and C cycle. Rebecca, can we put those small charts into the chat? That would be helpful. So buildings that had a file, for example, who had a block number, their last digit was 1, 2, or 3, had to file a report by February 21st of 2024. Okay. So right now we're going into the 10th cycle, right? The 9th cycle would be finished after that. And it's hard to believe there's 10 cycles of local law 11 already, now referred to as FISP, Facade Inspection Safety Program. So the submitter of the question talked about whether they should file early or not. You know, if you finished work recently and now your window is open where you could file your next cycle, absolutely, right? Otherwise, you're going to wait for things to occur that may result in a report that's not a safe report. Now, we're not going to file an unsafe report, and we're not trying to avoid that. But if you finished work a year or two ago and now your new cycle's up, why not file? There's no reason other than economics why you wouldn't file now or file at the onset of your window of when you could file. Okay.
I think also going along that route, when you're talking to your engineer about doing a report, have a good understanding of the differences between when you have something that you have to finish and what you have to put in a report. Because as Michael said, as in his premise, that you just finished work, and so you're coming into your cycle. Well, that may be what the inquiry was about. The question was, if you know whether or not you're going to need work, and the timing where you are on the cycle, it can control how you can contract, when you have to get the work, how you raise the funds for doing it, whether you have to do it early or later or have time to do it. So those are the factors you should go over with your contractor and or your engineer and management in doing some planning about whether it's late or early, et cetera. It'll all depend on what conditions you know about, and also what your timing is as far as being able to afford to do the work and or what work you think you're going to have to accomplish.
And you're also going to file a report that's either safe, meaning no work is necessary. You're going to file a report with swarm conditions with safe and repair and maintenance program. And that safe and with repair and maintenance program is going to be defined by the architect engineer submitting the report. They're going to dictate when that work has to be done. So clearly, if the work has to be done in a couple of years, time to jump on it and take care of it. But unlike previous cycles, you could extend this safe repair and maintenance program. No longer. You must do the work before the filing of the next report. Now, clearly, if there's unsafe conditions that are found, those need to be addressed immediately if they can, or a sidewalk shed has to be put up for pedestrian protection. So look, this is all about us and our safety. And if you're a terracotta building, it's not being too friendly in freeze and thaw cycles. Pre-war buildings, our buildings are getting older like all of us. So just, you know, like anything else, great maintenance, don't look the other way, and spend the extra money on the onset of the inspection so you have a good set of specifications and you could budget accordingly as well and plan. There was a question about natural gas detectors. Now, natural gas detectors in Class A buildings, which are most of, if not all of you, have to be installed within 3 to 10 feet of a gas appliance in every apartment by May of 2025. Now, there's a little bit of a problem with this. There's a wrinkle, and we're working on this with the council and with the Real Estate Board of New York. In the perfect world, you'd have a tri detector because you already have carbon if you're a gas building, which most are, and you already have a smoke detector. It'd be nice if you had a tri detector that did natural gas, smoke, and carbon. But guess what? Doesn't exist in a battery operated format. And the plug-in hardwired version doesn't seem that it's going to be around very long. So we're working with Kidda and First Alert and US Controls to try to see what they're going to do as manufacturers to possibly come up with a 10-year sealed battery device. Now, if I went out to the marketplace today and I wanted to buy a natural gas detector, that natural gas detector is either going to be hardwired or it's going to have a plug. And I don't know how many of the people that are participating or the residents in our buildings have power at their ceiling to tie into for the detector, or want to plug with a 6-foot wire hanging in their kitchens, which is typically where the gas appliance is. Now, clearly safety's first. So what we're recommending is just everyone sit tight for a bit. Let's see what the manufacturers say. And we're going to be reporting back from the council and the real estate board to the management companies with respect to options. And each management company is kind of looking to see what their options are as well. But right now, the perfect world doesn't exist. We don't have that 10-year sealed battery tri detector, nor do we have a 10-year sealed battery gas detector. So this just, was released recently. We have a bit of time, right? Over a year. But if we need tens and hundreds of thousands of units for the city, we better make sure the inventory is there. So more to come on that one. I would just sit tight for the moment. Called condo tax abatements. So there was a board that suggested that a unit owner or shareholder rather does not live in the building. It's not their primary residence. Now, the board and management do not become the real estate tax abatement police. Now, clearly, I say that in jest, but that's not really our requirement. Our requirement in the managing agent, if you're professionally managed, is to verify from the city tax roll that's provided who the primary residents are and who are not. Most management companies will send a letter to say that you're a primary resident, and if you're not, let us know. But as importantly, is you're listed as a non-primary resident, meaning you're not going to get the real estate tax abatement. And if you feel this is different, here's how you register to indicate that you are a primary resident. Now, while the city doesn't come out in written form and say what they use as their criteria, it's typically where you file your tax return. But again, and Ron and Bruce are on as our attorneys, it's not for the board to do an investigation of who's living there, who's primary. Somebody may be primary and you think they're not, but that's really not your role. So the city will then, indicate whether they're not. As far as the affidavit's concerned, that's usually done by the management company. But somebody could be a primary resident and not necessarily, live there full time. So I don't know if Bruce or Ron had anything.
Well, they switched the system a couple of years ago. It used to be that the buildings had to do more about corrections, and now they set it up so that as you put it, give them the information about here's where if you want to protest or say the city got it wrong, that here's what you can do. So that helps. That it's one less thing that the building has to try and be involved in and in fighting the Department of Finance on. The bigger problem is, at least from my experience, is where the city rejects somebody, and then it turns out that they go back and they say, you got to correct the fact that a couple of years ago the person was a non-primary, but he was getting the abatement, so we're now going to change it, and now you got to figure out who's responsible for trying to get the money back for the credit or maintenance charge credit that they got. So there are some issues that are involved in that still, but the city basically wants to make sure that they don't have to do the homework. It's the same reason why they have mandated that the system is that the co-op has to either give a check to the person or give them a maintenance charge credit against his monthly billing once a year.
Exactly. So let's go to a super hot topic, insurance. A lot of discussion about insurance, premiums, risk right? The primary objective for these boards, right, is risk transfer, right? Not to have claims are made all the time. As a managing agent, we're always named the claim. Probably attorneys not so much, but we need good insurance and we need risk transfer, right? And by doing so, we have to make sure that the people who are doing work in our building and our shareholders are covered. But in this particular case, there was a question about, are there any emerging risks we should be aware of? What's changed in the landscape? And what actions could a board or management company take or in tandem to mitigate those risks?
Sure. So I'm sure everyone's seen on the news the fires caused by the lithium batteries. So e-bikes, e-scooters, those are one of the emerging risks that carriers are really starting to take a look at. We've seen questions appear this year, January of this year, asking very specifically if they're allowed in the building. So making sure that if they're allowed in the building, that you have the right procedures and protocols in place, you know, where they can be stored, where they can be charged. Some buildings are just taking a position of an all-out ban. And obviously that's the carrier's preference. They prefer that these things are banned and not allowed in the buildings. They are causing fires. But if you are going to allow them, just making sure the right safety procedures and protocols are in place.
Excellent.
Yeah, I would also say, while it's not an emerging risk, the risk for every building in New York is New York labor law. If you're not aware of it, if you're not aware of 240, 241, and 200 and how it impacts your building and all the things that you should be doing in terms of contractual risk transfer, contact Bruce and Ron, right away so that they can help you put together the appropriate contracts to make sure that you can mitigate that risk going forward.
What Neil is talking about is the labor law where if I'm an owner of a company doing work and my employee gets hurt, our relationship is governed by workers' compensation, and so they're limited to what they can get, and but when it's a elevated or work or something that's dealing with gravity, the labor law then holds the owner of the building liable, and it's mostly in strict liability rather than negligence. And so it's very important in order to get around that type of thing that you have contractual obligations with your contractor saying, I understand that you and your employee have this relationship under workers' comp, but I've got liability for things that I can't really control. And so I'm going to want you to indemnify me. I got to make sure your subcontractors that you may use on the job does. And you'd be surprised at how many things are covered. It's not just the guys who are working on the facade on the scaffold. It can be literally somebody working on a ladder. So this is one of the big scary topics. And that's why it was mentioned before by Sophie, that whenever you're doing work or you're in the building, when you go out to bid, let them know what your requirements are and get somebody, and usually management or an outside insurance consultant or broker. Even we have some buildings where the carrier itself is requiring that you give them a chance before you can contract to look over what is going on with the insurance to make sure those exclusions that were mentioned before and other things are protected. The other thing they're doing is that when a shareholder is doing work attached to an alteration agreement, they want, just like I mentioned before in the access agreements, they want a separate rider where the contractor agrees to indemnify the unit owner and the insurance. So again, if something happens during that work, the building's policies come behind and not in front of the unit owners or the contractor's policies.
In fact, the current thinking is to make the contractors a signatory to the alteration agreement for that reason.
Right. Yeah. That's why you have a new rider to it, and the I've seen now almost every underwriter that writes for the big buildings or even small buildings is requiring those type of riders or separate agreements to make sure they're covered by that.
Yeah, we've actually created checklists for our clients, right, of the insurance terms and conditions that they should be looking for in every contract that they execute with the contractor. And it's not only just the contract, right? It's also imperative that you get a copy of the policies, because that's the financial product that's going to eventually, hopefully, pay for the claim. So in addition to having all of the right terms in that contract, someone needs to review those policies to ensure that they're actually going to perform.
Excellent. Thank you all. Thank you for the round table.
May I add something?
Sure.
We have also found that buildings need to check their violations. The premiums have gone up and coverage has gone down if you have certain types of violations, such as facade, boiler, or elevator. So that's just something to do your due diligence before your insurance renews, because it may take some time to get those violations removed.
Yeah, I'll say particularly the Class C violations, those are the ones that the carriers look at the most seriously. But there are programs out there. Many carriers now, they never used to check the HPD or DOB websites. I'd say almost all of them are checking them now. And if you have open Class C violations, you're very likely going to be declined by many of the carriers.
We talked a little bit about indemnification clauses. So change gears a little bit. I'm going to come back to insurance because there's a lot about insurance, not only this evening, but every evening. So Sophie and Neil, thank you for contributing. Bruce, proprietary leases, many of which, you know, when co-ops were converted in the 80s, may have a lot of stale language in them, right? Ambiguous language. What about the indemnification clause of the proprietary lease? So it kind of matches or, you know, is in line with what's going on in the world.
Actually, there are two separate concepts at work here. One is indemnification, which is where board members are reimbursed for legal fees, which they might incur in connection with shareholder suits against them. And the other, and I think far more important one, is the concept of exculpation, where board members are actually, under certain circumstances, protected from legal liability for what they do as board members. And so there are two separate concepts which you have to look at. And neither one actually is in the proprietary lease, Michael. The indemnification is covered in the bylaws, and exculpation is covered in the co-op certificate of incorporation. So those are the documents which are relevant, and those are the documents which to which amendments should be made in the event that they haven't already done so. The proprietary lease then is not really relevant to that discussion. You want to amend the bylaws to the extent it hasn't been done in order to, because the business corporation law now allows board members to have their legal fees advanced prior to there being an adverse verdict or judgment against them on liability, if the bylaw provision on indemnification allows for that. So you do want to update your bylaws to provide for indemnification to the fullest extent permitted by the business corporation law. Most buildings have already done that because, as Michael said, the business corporation law was amended in the 1980s, the late 80s, and most buildings reacted to it at that time. If your building has not already done so, now would be a very good time to do it. Similarly, in the late 80s, the business corporation law was amended to allow for exculpation of board members from any liability for negligence that a shareholder might allege that they permitted in the course of performing their official duties. But that in order to get the advantage of that for board members, the certificate of incorporation has to authorize that exculpation. So if you haven't already done so, and most buildings have done so, then now would be an excellent time to amend your certificate of incorporation to allow for exculpation as well as indemnification. And a board wants to take on both of those amendments because otherwise you're going to have a great deal of trouble persuading shareholders and unit owners to volunteer for positions for which there is otherwise legal exposure and financial exposure. So these
Bruce,
are very good ways to do that.
so the bylaws are clearly focused on the corporate governance of the particular co-op, and while the proprietary lease talks more about operations. But if a board is going to look at their indemnification clause, I think it would behoove them to have their entire bylaws reviewed if they're dated back to the 80s.
Absolutely, and also for that reason, you should also review your proprietary lease, because there are a lot of aspects to building operation on in the habitational side, which is what the proprietary lease covers, and innovations and legal decisions which the 1980s type of proprietary leases do not address. So it behooves boards to be proactive and take a look at their documents and have them analyzed from the point of view of a global amendment process to update.
There is one section in the proprietary lease that talks about indemnity, though, and that has to do with the being responsible and indemnifying the building for things that the shareholder or their household do, or actions that are in violations of the proprietary lease. And this comes into play a lot in, again, hooking into the insurance part, because it says they have to indemnify them except if there's something that's covered by the building's insurance. And then they do something called a waiver of subrogation, which is a concept that everybody looks to their own insurance, and if the insurance company pays you, you don't go back after the other actor. You just take what you get from your insurance company, and that's in both section on the indemnity that's in most proprietary lease, but it's also in the section on casualty losses, where there's the building has broader responsibilities than most people think as to what they have to fix after some type of accident. And it's not just for fire or a major thing. It could be somebody's ice maker where it leaks, and the building's policy will cover it because it's an accidental issue. It floods down 2 apartments or 3 apartments, and then everybody's trying to figure out whether it's the homeowner's insurance that has to fix it, the building's insurance that have to fix it, who can go back. And so when you're talking about how to maintain your risk, it's one of those things. And in some of the newer condominiums, you see there's a much finer line as to who repairs what after those losses. And so if you're going to try and manage risk, some of the newer condo acts say, okay, if there's a big fire, we only have to put back the structural stuff, but we don't have to do the old original cabinets and stuff like in a co-op or in older condominiums. And so if you want to manage risk, draw the line saying, okay, we do the structural, and everything within the unit has to be done and covered by the homeowner's insurance. That's that risk management. And sometimes in your documents, the problem with that, remember, is that both the proprietary lease and in condos, the bylaws, where you would have to amend, take either unit owner or shareholder supermajority votes to get anything passed. So it's a long haul to try and redo those things after they've been in place for so many years. But there's a lot of misunderstandings. I'm sure both Jessica, Sophie, and Neil have seen it, and certainly Michael, and I know Bruce, about people figuring out who repairs what when there's a problem, and that's where these insurance and indemnity provisions and even parts of the alteration agreement can be coming into play.
So let's get our governing documents up to date, whatever that means for your particular building. I had one case where it took us 2 years to get it passed, but we got it passed. Switching gears a little bit, what trends are you seeing in buildings? Are they going no smoking, no dogs, environmentally friendly changes? What's the process, the pushback? What's going on out there? For a moment.
I can hop in. A topic that Sophie and I have seen quite often has been the installation of AEDs. A lot of buildings are asking us if they can put, defibrillators into their space to protect and safeguard their their residents. And the general answer has been yes, you can, but there's risk management protocols that need to be implemented in connection with that request. And by the way, you should also talk to your insurance company.
Yeah, probably train your staff as well. If you're a
100%.
union building, the trainings, throughout the union. If you're non-union, it's not expensive to have people trained in AED and CPR certification. It's a good idea to do so. Going back to insurance for a moment, and Neil, thank you for segueing right into that. In addition to requiring homeowners insurance, what other things can a board do to protect the co-op from liability? One particular board is thinking about a disclosure, and maybe this goes back to the lawyers, that shareholders would sign if they have dogs. It's becoming an issue. And look, the unfortunate reality that even if they sign indemnification, I don't care how well it's written, or they sign disclosures, whatever you want to call it, if their insurance has holes in it or exclusions in it, the indemnification, while you may have recourse, may be worth the paper it's written on. So we want to start with, we want that insurance coverage, right? We want that risk transfer. So what would you like to share about that?
I think we kind of have hit pretty hard on that. It's thoroughly vetting vendors, specifically contractors that come to work in your building, making sure that all shareholders or unit owners do have their own homeowners policies. That's, super important. Like Ron mentioned earlier, both parties are going to be responsible for different damages in the event of a claim. So you could have shareholders or unit owners that think the building's going to cover everything, and it's really not. So it's really important for all shareholders and unit owners to buy their own insurance. You can have people, if you've got gyms, you can have people sign waivers, post rules. If you have pools, post the hours, really just making sure you're doing everything that you can to protect yourselves. But you can have people sign waivers and they can still sue you anyway. So,
all good points. Sophie, I would say,
go ahead.
I'm sorry, Ron.
They're out of date, but there's also an enforceability issue on waivers, and many courts are disregarding them as a matter of being contrary to public policy. So you could have the waivers that acts as a good deterrent effect, but it may not act as an enforcement device if somebody challenges them.
It really depends on, again, having certain rules and also taking actions to actually enforce those rules, because the fact is that where most people get into problems is they turn their head and say, I don't want to get involved, and yet not getting involved sometimes is worse, because you're putting yourself in a position where you've set up rules and you don't follow them, and then somebody gets hurt, for example, in your pet responsibility. You don't become responsible for somebody whose dog has it and is jumping or biting somebody unless it has a propensity to do so, and you're notified of it, and then you don't act. And then, as Bruce brought out, the state law says you can't waive your own, as a landlord or owner of the property, you can't waive your own negligence and contract it away. So, and ask somebody to indemnify you against your own acts. So it's really a matter of making sure, if you have certain rules like leashes, or somebody's brought to your attention that there's a problem with the dog, or something else like that, you got to make sure that you then take reasonable steps to enforce those rules, so that you don't get caught on they didn't act after they knew, and then create negligence where you might not have had any responsibility at all had you not, if you followed your own rules.
And dogs are a perfect example of that, because if the building is on notice, then the building really does have to take an aggressive stance against a shareholder or unit owner whose dog has a history of snapping and biting.
Neil, we have a building that sprung a leak, or many leaks. And, this board is inquiring about, they're having more and more leaks due to wind-driven rain. And they're doing what they're supposed to do, right? They're being a prudent board. They have a project in place. They are working on making repairs, but they're concerned about the leaks that are happening and because of the insurance claims or the effect it has on insurance. Now, water damage, in this particular case, will typically have a deductible on it, right? And what's your rule of thumb? A couple of points to this question. Number one is, what is a common deductible for this type of work? And let's say a building had a $10,000 deductible. They have an $11,000 claim. Do they make that claim? In this case, they're $1,000 over the deductible. Like, what's the rule of thumb for making a claim, not making a claim? Insurance is 4 claims, but yet you don't want too many claims because it raises your insurance. So, it's kind of a mixed bag. But, we typically looked at it like it's for these big claims, but you're paying a large premium. So where does somebody go?
I want to make one point, Michael, before Neil interjects. The wind-driven rain is not something that's covered by many policies. There typically has to be damage to the exterior of the building that allows the water to get in for there to be a covered cause of loss under your policy. There are a handful of carriers that do cover it, so I don't want to say it's not available in the market, but it's not widely available. So that type of claim might just be outright excluded in the property policy altogether. But, Neil.
And let's go on an assumption, because they wrote that they're doing repairs. They know there's something wrong with the building. But either way, it kind of runs parallel. So Neil,
that could fall wear and tear also, but.
Yeah, so I would say definitely rely on your insurance professional's advice. If you have a number of, to your point, $11,000 claims and you have a $10,000 deductible, eventually, if you start putting those in, they're going to catch up to you, and you're going to either get dropped by your insurance carrier, your premium's going to skyrocket, or you might not be able to find coverage. So I say work with your insurance professional, ensure that what you're doing is prudent and you're not going to impact renewals down the line. But typically, we would not put claims in for low amounts like that when they're so close to the deductible.
Excellent. Thank you about that. More insurance. As I said, it could be the whole
hot topic, and the biggest expense probably going up for most boards in the last couple of years. The sticker shock has been unbelievable.
Especially on the umbrellas. There's been no questions about it. So I'm staying away from for now because we don't have enough time tonight. But going back to Neil and Sophie, what is your company's recommendation to a board that comes to you and says, we have people that want to do alterations in their apartments? What should the coverage limits be? And I know I'm asking you a question that's subjective within reason, but give us kind of a rule of thumb.
I mean, our standard recommendation is that any contractor that's coming into the building doing interior work carry, your standard $1 million per occurrence, $2 million in the annual aggregate on their general liability policy, plus a $5 million umbrella. We've talked about these labor law claims all night. These claims happen all the time. And when they do happen, I don't want to say never, rarely settles under $1 million. Those umbrellas are super important.
So what I usually say to clients, Sophie, is I say, let me give you 2 scenarios. 1 million per claim, 2 million occurrence, and a $5 million umbrella. Or a 1 million, 2 million with $50 million umbrella, but the $50 million umbrella has action over exclusion and all these other things going on, right? So what's the better policy? Clearly the 5 million. So again, Sophie's spot on. I think it's a really good recommendation, 1 million to 5. Again, you don't want to have it too high where vendors can't afford it.
Right.
You exclude the pool of who you could select, but you still want to have enough coverage based on what's happened in the world of claims. So each building will make their own determination, but what's the most important aspect of this is, what does the policy contain? And if you're with Neil and Sophie, you send them the policy for review, right? Yep. Because if there's a lot of exclusions in there and the labor law exclusions in there, again, I keep saying it's worth the paper it's written on. That's where you really expose yourself.
Yeah, I mean, we've seen.
Don't just rely on the COI. Everyone says, I got a COI, I'm good, it's fine. No, the COI is just evidence of insurance. It doesn't provide any legal rights. To Michael, to your point, it's worth the paper
It's
it's
not,
running on. So
it's suggested what they think is it's not binding. The broker has
Yeah.
no liability for producing it. So basically it's become over the years, everybody says, oh, I looked at the certificate of insurance and they had insurance, but nobody looked at the policy, and they find the what's on the certificate of insurance is in many cases it's not even accurate, because it doesn't tell you anything about exclusions or other things. There are other forms that people use, but unfortunately for most jobs, nobody wants to take the time to fill those type of forms out that would actually list some of the exclusions and things in it, because the broker doesn't want to take that on. And the contractor, in many cases, the contractor that goes to his broker and he says, I need this type of policy. And they say, well, here it is. And nobody then read it, and the contractor then later on finds that he thought he had insurance that's not there either, besides the building. So,
which is precisely why I recommend when a building is imposing alteration agreement requirements, that they require the person doing the alteration to actually pay for an insurance broker's review of the policies themselves, so that they can make sure, for the building's sake, that they are compliant. That
Bruce, send your clients to us, please. That's great. Wonderful.
Create a new business.
As far as I'm concerned, it's a cost of doing business, a cost of doing the alteration. I think it's absolutely legitimate in light of the court decisions that say that the COI is not binding.
the other thing just to
I don't
remember,
protect
if you're doing it for alterations, common sense, unfortunately, is not necessarily useful here, because you're going to have shareholder revolts sometimes, and I'm sure Jessica's faced this, where and Michael, and when you were badging, I mean, the guy so and so is going to do alterations that consist mostly of painting, or very light stuff, and so he says, I got so and so who's going to do it. He's a small contractor. He's lucky if he can get a couple $1 million worth of insurance, let something that has a $5 million or $10 million umbrella to it. So, half the time people are concerned about bringing in contractors such as painters, and thinking that for those type of alterations, I don't want a 20-page alteration agreement. I don't want to get this heavy insurance requirements. And sometimes you start getting shareholder feedback saying, I can't get a contractor who can meet up with your standards. So
it's all about awareness. They can't get a contractor if they want to pay at that price. But the reality is that's the contractor that falls off the ladder.
right.
I'm going to go to Jessica for a moment. Jessica, on sustainability, any subsidies out there, for co-ops who want to improve their energy efficiency and sustainability? Are there any kind of, monetary considerations out there for them?
Oh, yes. The NYSERDA, this a state-funded incentive program, has a Flex Tech program for condos and co-ops to have a decarbonization plan done with a 50% incentive. It also includes your local law 87 mandated 10-year energy audit. So you get a 2-for-1 deal. There's a lot of utility incentives through Con Ed to assist in things such as like steam trap replacement and pipe wrapping and various others. And now with the federal IRA monies, you can actually stack that with NYSERDA incentives, and it all depends on what your project is. They have incentive programs where the more you opt into certain type of projects like facade and roof, then you would get higher price per unit incentive towards your building. There's a lot of different options. So you can reach out to NYC Accelerator. It's a free service through the city, and they can review your building and let you know what you could qualify for, like a free white roof program. And then you would have to find a qualified vendor to get those incentives, because the board can't apply for that. A qualified vendor would have to do that.
Excellent, thank you. And I guess we all know that if there's an incentive out there that you're interested in, put the paperwork in because the money goes away and then it comes back, hopefully. But, you know, a lot of these pools dry up very, very quickly. Jess, we're going to go back to a question that we discussed earlier about any type of trends, you know, in buildings. You see anything, you know, changing with respect to rules or restrictions?
We are seeing a trend in smoke-free buildings. Whether that's enforceable, is really you can't stop someone from smoking. You could find them, you can figure out through your documents, but then, like they've said before, you can get sued for anything. The same thing with, they were talking about dogs. You can put in policies. People have put in pet policies, so it doesn't prohibit dogs, but it can prohibit dogs that have an aggressive nature. But by putting these trends are also limiting the pool of buyers and coming to your building. So you really have to look at the culture of your building versus how much opportunity you want for people purchasing in your building, and make a decision on what's important.
Thank you for that. Bruce, there was a submission about frivolous legal action against their co-op by an individual not even affiliated with the co-op, which is, I've heard of it before, but this is very rare. Now filed 7 lawsuits in Kings County against their co-op and board members. So somebody doesn't like that co-op and doesn't like that board. It's not affiliated. So I don't know the reasons behind it, but it's certainly troubling and upsetting if you're a board or a building, right? Nobody wants a lawsuit. We talked a little bit earlier about violations and insurance and things like that and that effect. And in this particular case, they feel, you know, they're victims, right? And they have no way to protect themselves. So, you know, what could you do in this horrific matter?
Well, unfortunately, the key word here is that the person bringing the lawsuit is unaffiliated with his target building. So objectionable conduct obviously does not apply here. Obviously, you can't prevent a person from filing a lawsuit. However, I am aware of at least one case in which a judge has said, I'm going to impose some kind of prior restraint against unaffiliated people filing lawsuits against buildings. And what the board did in that instance is they went to the judge and they said, we are being vilified by a neighboring person, and help us, judge, impose, we're now the victim of 7 different lawsuits. Make sure, and none of them, they've all been dismissed against us. So therefore, what we would like you to do, and this was a novel approach, and I've only heard about it once, so it's not something that's established custom or established precedent, but the board's attorney asked for a prior restraint order that restricted this person from filing another lawsuit against the building unless he came to the judge and asked for told the judge what it was about and got prior clearance from the judge in order to file the lawsuit. So far as I know, that order that the judge granted was not appealed, and it imposed some kind of order because it required the person harassing the building to come to the judge first and say, this is what the lawsuit is about, and get some kind of clearance from the judge before he could go file the lawsuit. And the problem, I understand, anecdotally went away because now that he had to go get his prior clearance from a judge, he was no longer able to indiscriminately abuse the system by filing lawsuits against the building. So that might be a good precedent in the future to use for this person to use. It took guts to ask for that kind of prior restraint offer. And frankly, I think it took a lot of guts on the judge's part to issue the restraint. But I think enough judges are now aware of the fact that board members are volunteers and they are not asking for this kind of abuse from external parties. And if there is a proven history and a proven pattern of frivolous lawsuits and a history of prior dismissals, it might just work.
Thank you, Bruce. Appreciate that. There was a submission about different ways of raising money for their buildings capital projects, whether to transfer from reserve versus assessments, how does it impact taxes, and also about maintenance increases and kind of some, I guess, barking from shareholders, even though the board attached letters and articles about increases in trends in the industry. So first of all, on the capital projects, the rule of thumb is that operating or maintenance should be recurring income versus recurring expenses, and shouldn't really be used to pay for capital projects, with a caveat: if you want to set up a line item that replenishes reserve in your operating budget, and more power to you. I think it's a great practice. But to fund capital projects, they should be done by any type of grant. We spoke about NYSERDA before, Jessica did. Also an assessment, line of credit, reserve fund, additional borrowing, combination thereof. So a lot of different ways to do this. Certainly there's debt service associated with additional borrowing. And you also have to check your current loan if you have one, because there's typically a restriction on additional borrowing unless it's from the same lender. So there are a lot of moving parts here, but if you have an adequate reserve, use it. If you need to borrow more, it's not as easy in this high interest rate, or it's not as hard, but you don't want to go in an interest rate environment that's higher than it has been in the past, or use a combination. There are also buildings that assess and give people that pay immediately no interest, and people that pay over time, they bear some of the interest that goes along with it to make it a little less burdensome for people. As far as the maintenance increase goes, again, not understanding or not knowing what the amount is. So if this is something that's not going over well for your particular building, or you're approaching double digits on a maintenance increase, I'd call a special meeting. I think it's really important to not always just send notices, that the board could say, we're about to do an assessment, or in this case, a maintenance increase. Here's a copy of your budget, and do a screen share, since most buildings are meeting by Zoom. Here are the reasons for it. And I think that boards, don't feel guilty about a maintenance increase. I mean, you're paying it as well. You have an obligation to be fiscally prudent. And I've seen too many boards over the years where if there's a maintenance increase that's projected at 8, you try to trim it down and make it 6. Now, if it could really go to 6, do it. But if it's really 8 and you're concerned about how it's going to be received, you're just hurting yourself and the co-op as a whole, because next year you're starting in a 2% hole, all things being equal. So look, every building is different. We think transparency and communication are certainly super important. And, put the memos aside for a bit. Do a half-hour Zoom. Do what we're doing this evening. Get out there, get in front of people, do some Q&A, show them the numbers, and I think they'll understand a lot better. Nobody wants to pay more. Nobody on this Zoom, and nobody in your building. That's for sure. Organics and recycling. Jessica, we had somebody write in that they put the organics out there, and guess what? They're still out there. Nobody's coming to pick them up on time. What's the board to do?
Well, you can put in a 311 call that alerts them. Encourage everyone in the building, because the more 311 calls about the same issue, they will show up. You may have a contact through your management company to DSNY that can contact someone and let them know that it wasn't picked up. It has personally happened to me, and by putting in a 311 call, it worked.
Thank you. You know, Sophie, we spoke about, and Neil, about a recommendation on vendor, contractor insurance working in a building. What about a shareholder? And look, we know there's apartments that are, well, I guess in New York City, more hundreds of thousands of dollars, and there's apartments that are $30 million. But we're really concerned about the liability aspect, right? If their contents gets damaged, we feel terrible about it, but if it's not all of it, it doesn't adversely affect the whole co-op. It's that overflowed bathtub, it's God forbid a fire in their apartment, smoke, you know, something they generate and cause damage to others that a liability policy would cover. What should be the rule of thumb for typical homeowners?
So we typically recommend, you know, like you said, we tell boards they should stay away from recommending minimum property limits for exactly the reasons you mentioned. That really should be a conversation between the shareholder or unit owner and their broker, and they should do a thorough review of the proprietary lease or the bylaws to see what they're responsible for in their unit to ensure, whether it's the floors, the kitchens, the bathrooms, etc. And then they're going to be the best one to know what their furniture, clothing, valuables, etc. are worth. From a liability standpoint, we typically say you should recommend a minimum limit of $1 million. But again, liability should still be a conversation between a shareholder and a unit owner and their insurance broker. You know, people can sue you for any amount. This is your personal liability as shareholders and unit owners. And to your point, Michael, if someone leaves their bathtub running and it goes down a whole line of units, while there is a waiver of subrogation between building and shareholder and building and unit owner, that waiver doesn't exist between shareholder and shareholder or unit owner and unit owner. So if you cause damage to someone else's property in their home, their insurance carriers can come after you for those damages. So we recommend a minimum of $1 million, but in many cases that may not even be enough.
And that's even referred to as a renter's policy, even though it's a co-op, correct?
It's usually referred to as an HO6 homeowner's policy, so a unit owner's policy. But if people are subletting, you know, they should still maintain insurance for the unit that they own and then also obtain proof of insurance from their subtenant.
And the part that you were talking about as far as the property, it's one thing to cover your clothes and your furniture, but when you're talking about things like cabinets and things like that, that's called the betterments and improvements.
Mm-hmm.
And that's part of that homeowner's policy because the building won't replace those. And if you have to replace them yourself, you make sure that that renter's policy that somebody gave you has that really a co-op owner or condo owner's policy with the betterments and improvements in it.
Thank you. On insurance renewal, so Neil and Sophie again. Building, small building was rejected, or their insurance was canceled rather, for not having a central station alarm. Now, almost all pre-wars don't have central station alarms. So what are you seeing out there with this aspect? Is this an anomaly? Are you seeing it often? You know, look, you could always get insurance. The question is what it's going to cost you to get it. So what do you see in this particular case?
So being non-renewed for not having a central station alarm makes me think that something was misrepresented to the carrier at the time of binding. So making sure that your broker is collecting the proper information on your building, you know, are you fully sprinklered? Are you partially sprinklered? Do you have hardwire or battery operated smoke detectors? All of that information is very material when the broker takes your building to the marketplace because different insurance carriers have different requirements for what they have to have in a building to offer a policy. So if you were non-renewed in the middle of the year, it makes me think that they were told there was a central station alarm and one was not there. That being said, that, you know, like I said, there are different requirements for different carriers. So the buildings out there that are going to struggle the most in the market right now are buildings that are 6 stories or more, that are not fully sprinklered, that don't have central station alarms, and that don't have a second means of egress. And by second means, I mean 2 interior stairwells or an interior stairwell and fire escapes that run floor to roof, and that every unit has access to those 2 means.
Especially in buildings that are wood joist construction that are not fire restrictive. Those are the ones that are really in trouble.
Correct.
One of the things you got to know is whether it's fireproof or non-fireproof building, because they're going to do different requirements. And there was a recent case where somebody didn't very carefully look over the application and didn't check a box, and it turned out that the carrier was making an assumption based on what was there, and then it turns out that it was not a fireproof building, and so there was a whole different set fact pattern. They canceled the insurance on the claim.
Yeah, so those types of misrepresentations, to the extent that they're material because they're against underwriting guidelines, can result in a rescission of your policy. So they'll literally take the coverage back, they'll write you a check, and they'll say you're no longer covered. So it is important to make sure that when you're filling out those applications, they're done accurately and they're done by a professional in conjunction with, the board or whoever it is that's required to go out and procure the insurance.
And make sure and double check it. It's it's like we talked about before. Don't rely upon approximately 24,000 square feet. Make sure you look at the C of O and the other documents for your building, so those type of things are covered.
Bruce, building switched board meetings. I have a two-part question for you. Board switched to board meetings on Zoom, then email during COVID, and their email threads among board members, could those replace in-person meetings? Could the threads replace them? What do they need? Do they need voice? When does email count? When doesn't it count?
Well,
what do you suggest?
first of all, there's no substitute for virtual meetings. Emails do not count as meetings. You either have to have a virtual meeting or you have to have an in-person meeting. So the email threads do not constitute a meeting. They can constitute notice of a meeting, but the meeting itself has to be by a median where all board members hear each other at the same time, because that's how the dialogue, which forms the basis of legitimate board votes, occurs.
Thank you. Then there was another board where the board president, as shocking as it may be, is not sharing the co-op's documents with the other board members. So number one is certainly not the way it's supposed to be. And what recourse does the rest of the board have, and what should they do?
Well, not only isn't it the way it's supposed to be, but it's absolutely illegal. And the reason it's illegal is that every board member has an absolute right, as a matter of law, to access to every corporate document. And the reason for that, courts have said, is that any board members have a fiduciary duty to properly perform their function as board members, a fiduciary duty to their shareholders and unit owners. And the courts have reasoned that board members who do not have unfettered access to each and every corporate document cannot possibly perform their fiduciary duties properly. So the rule is that any board member has an absolute right of access to any corporate document. So the board members who are being denied access need to circumvent the president and go directly, make a demand on the written demand on the managing agent and on corporate counsel, and for any access to any record that they want. And
in most buildings, Bruce, the board can remove an officer, correct, in a co-op?
The board can remove an officer. You can't remove him as a director, but you can remove an officer, absolutely. So if it's a majority of board members, they can remove the president and deal with it that way.
Right, so that may certainly, address the issue, except for the stuff they're harboring. There was also a question about a superintendent. In this particular case, a board wanted to provide a superintendent with additional compensation. Superintendent, 20 years of service, probably a stellar superintendent, delayed their vacation, helped with a capital project. And this board was considering giving them 2 weeks additional pay. Do they have to clear that with the union? Are there any potential negatives to doing this? So the answer is you do not have to clear it with the union. You should mark it as a bonus. You're calling it 2 weeks extra paid vacation. Just call it a bonus. And as long as you mark it accordingly, you won't be in a position where that becomes part of their regular pay in perpetuity. It's unlikely, regardless of what you do, Will. We're not talking about a huge sum of money, but feel free to recognize your good employees. I think it's great. You know, from a tax implication, you know, maybe just giving 2 extra weeks pay, call it extra vacation pay, will be a very nice thing. Maybe have a card with it as well, but no issue to get cleared by the union ahead of time. Reserve fund studies, you know, what scope should be included by the architect or engineer. So for those of you who do not know, reserve fund study will look at, you know, all components of your building, including the exterior, and say, here's your building, here's based on values of you know, life expectancy of different components. This is how long things will last. This is how much money you have to set aside on an annual basis. And usually these are 10-year projections, but you can go out further. And in this particular case, you're asking what scopes should be included, but I'm assuming that it's what should be included in general in it. You know, just stick with major components, I think would be a safe approach, where you look at, you know, typical building, water tank, elevators, boiler, exterior. If you're a pre-war building, all of your plumbing's exceeded its useful life, but you're not going to go in and replace all the plumbing because the restoration costs are so large. But you should know about the major components if you want to plan ahead. Now, the aspects of the reserve fund study, in my opinion, are subjective to a certain extent, but I don't see a lot of knowledge in knowing that my old plumbing's old. But, you know, if it's galvanized and you're 80, 90 years old, that galvanized plumbing is not going to last much longer, but there are ways you could address that systematically by having it changed on gut rehabs of alterations, replacing one riser at a time, things like that. So I think it's a combination of major components and just a kind of holistic approach as to what you want to do. Because remember, once you get that document, what are you going to do with it? I mean, knowledge is power, but are you then going to take a $10 or $20 million loan? Are you going to assess your shareholders based on what comes out of the reserve fund study? So I would just say buyer beware within reason. Really think it through. What is the goal of having the reserve fund study other than to know that your building's old and it's going to cost you X to do it? So I'm not being nonchalant about it, but I just want you to really think hard about what you want to do as a building and really what, you know, where you are economically. But again, knowledge is definitely power.
And also you should make sure that there's not a requirement under your underlying mortgage to have to perform one. So before you make the decision, you should consult with your management and your attorneys to see what's required. Because in some cases, we're getting some of the Fannie and Freddie Mac guidelines are now, and some lenders are making requirements not only to have a line item for a budget that has reserve funds, but also requiring for selling individual loans or for shareholders or unit owners, or also the boards, if they're borrowing money to do things, making requirements to have some type of reserve fund studies on your useful life.
So we're in overtime, but we're volunteer panelists, so we're going to continue to go into overtime, but we're going to speed along a little bit. Ron, you know, what about record retention? You know, if there's an opt-on platform, somebody wants to put things into the cloud, do they have to retain a hard copy? What's the rule of thumb on documents in general?
Well, a lot of it goes by good sense rather than legal requirements. There are some things that it's good idea because you may need those records in the future. So we always recommend that things that are, for example, That might be financial records that might come up for an IRS audit or something like that, where you're going to need certain documents. Usually you can use a 7-year for most records, breach of contract and things like that with contracts. So contractors and payments vouchers for contracts and audits are usually something around here. You should keep them for probably 6 or 7 years to make sure. As far as keeping originals or not, there are certain things that you have to have. So, for example, each apartment should have a copy of the stock certificate that was given to the shareholder. They should have the duplicate original, because there's 2 of them, one for the shareholder and one for the board, in that file. And you should have copies and or originals of things that are agreements with each shareholder, such as a recognition agreement, which is the agreement between the bank that made a loan to a shareholder, the co-op, and the shareholder, and also things like alteration agreements, because as those things may come up in the future as to who's responsible for what work was done. And so you should definitely have those, because even if you don't have the originals, on site, you should definitely have access to them, and you should then have them scanned in, so that in today's technology, so that at least you can look it up and make sure if that there's an inquiry.
Excellent, thank you. Just in the interest of time, since we are over, if anyone is still remaining with us, and I see from the attendee list that most of you have stayed with us for the hour and 40 minutes so far, so thank you very much. I'm glad you're enjoying what we have to say. But if your question was not answered yet live, please just put in the chat to me that it has not. We'll address it now. If not, we're going to wrap up shortly and we'll answer questions in the next day or so, via email. But I'll see how many more we could kind of get through for you. Okay. So on LLC requirements and reporting, Bruce. Recent legislation about disclosure, not disclosure. What's going on out there?
Well, it's kind of a mess because the Corporate Transparency Act was recently declared unconstitutional by a federal judge in Alabama. So that's thrown everything up in the air. But pending my experience is that people are going ahead and treating the Corporate Transparency Act as if it is going to be enforceable until the U.S. Supreme Court says otherwise. And in the co-op and condo world, people are taking the position that the controlling persons, such as council and board members, are subject to disclosure requirements. So I think people are being conservative. They're acting as if it is going to be binding.
Thank you. There was a question about water bills. What about initiatives being explored? What's available for a particular building? So there are buildings that go to low flow shower heads and faucets, and they put in restrictors. The problem is that many of those cases, the person taking the shower after that restrictor is installed is not very happy. So it reduces, your shower is a little bit longer. It may not be as fulfilling. So, all kidding aside, that's been some of the problems with it. We all want to save water. I think it's also important that depending on what type of building you are, so if you have tank and bowls or you have flushometers, be surprised what one running faucet can do. We would recommend sometimes to a superintendent, or if you're a door person building, it's easier, but if you're a superintendent without staff, get up like 4 in the morning and see if the water meter is running. Right? Put a camera on it, because why say 4? Maybe it's 3:30. Most people are not up. And if that thing's spinning, we know we're wasting water. And another way to waste water is during the heating season, put a gauge on how much fresh water is filling your boiler, right? Is it within the normal parameters? That means you have return line leaks. And those are two ways to deal with it. From a service point of view, for example, and I'm not endorsing this company, I'm not part of it, but there's a company called Wastewater Management. I don't know if there's others that you know, Jessica, off the top of your head, but you can call somebody like that. What they do is they go in and look at your bills to see if you were overcharged. Now, you could be overcharged for different reasons, but from a water conservation point of view, it's low flow toilets, it's low flow shower heads, it's faucets. You know, you'd be surprised you're a big corner building and the staff is hosing the sidewalk down for 5 hours every day. Maybe you hose it down every other hour. Do you have a sprinkler system? You know, things like that. So there are things that you could do that are very subtle changes that won't affect people too much that could definitely help you.
And if you have cooling towers, you can hire a company to put a meter on that, because you can also look at that as wastewater as far and as landscaping as well. And there are companies out there that have leak detection systems that you can put on pipes, and they can let you, and it automatically notifies you if there's an abnormality on the pipe.
Okay. There was a question for Ron and Bruce about late fees. Is there a general norm that's reasonable under the law for assessing fines for late maintenance payments? There's a culture in this particular building withholding fees, right? So that we just have late payers or people that can't pay. And right now there's just a $75 per month fee, which doesn't appear to be a deterrent.
Unfortunately, $75 is probably illegal because I believe the current is 8%, the current legal limit. So
Well,
Depending on your
it
maintenance.
depends on the building. Remember, the co-ops were thrown, they originally, when they passed the Tenant Protection Act, they had caps on those, but then they exempted some of the co-ops. So the big problem is that your lease has provisions for, usually reads that if you don't pay on time, you get interest at the maximum rate allowed by law, which is for an individual 16%. And for corporate or non-individuals, 24%. The problem is people charge late fees, and then the courts are very wary about enforcing them because most of the leases don't have a provision that gives you late fees. Unless they've been amended as part of those reviews we talked about earlier about updating your features. But the courts will allow, quote, reasonable administrative fees. So, you know, you're talking 25 or 50, but it can't be cumulative where it starts at 100 and then you charge 100 more and then 200, and the courts are not going to enforce those. So
I think most courts are coalescing around 8%. At least that's my
well, again, because of the thinking in the L&T terms, and
right.
in co-ops that are technically landlord and tenant, but there's an exemption for the statute. The problem, if you want to wake them up, is very simple. You charge them the maximum rate allowed by law, and then it becomes basically less of an attraction for use you as the bank, because paying a $50 or $100 bill is not going to bother somebody, but paying 16% on arrears, especially if they're running up $2,000 or $3,000 a month in unpaid bills. And then cleaning them up later on, it becomes economically disadvantageous to them. Not to mention, if they do have a bank and you're a co-op, if you notify their bank and you have a senior lien to the bank, they're going to want to make sure that you don't go and foreclose on your lien, because you're owed a lot less money than the bank, and you can control the foreclosure sale. So most of the time, notifying the lender will get you paid.
Last question for the evening on legal, not insurance and not property management, not compliance. A naughty property manager. The property manager will not provide information about insurance claims, will not provide details about what's going on in the building, but only allegedly, right, based on the submission, that only corresponds and speaks to one board member. I'm assuming the president.
and you fire them, they usually have a 30-day clause with or without cause. So
Right.
that's a simple one. It's the
So,
bigger problem usually comes up is when shareholders ask for a lot of information, and there's a big difference between, as Bruce said, the board members are entitled so they can, under Business Corporation Law 717, fulfill their fiduciary obligations. They can't do it without access to information, as where shareholders have a very limited right to books and records and other things under the cases. So if the managing agent is not doing their job, if it's an employee of the managing agent and not the company, then you go to the head of the company and you have that conversations. And in most cases that will get it, but many times it's misguidance because they think they have an allegiance to the person who's the president or an officer that brought them in, versus understanding that all the board members are equal when it comes to access to that type of information.
and as we said earlier, as Michael pointed out, it's majority rule when it comes to a board's decision to fire a managing agent.
There was a question about whether we released a recording of tonight. I'll leave that to you, Rebecca, to write to the people that attended this evening. Jessica, Sophie, Neil, Bruce, and Ron. I don't know. I'm juiced. I had a great evening. This is one of our series of our roundtable discussions. We have more this year, presented by the Council of New York Cooperatives of Condominiums. If you're not a member, please join. If you are a member, please renew. Got a lot of great stuff today. And even at this stage of our careers, hearing each other speak, we all come away with learning more and more. So, we love this industry. A lot of great takeaways. Thank you all for the people that joined us this evening. Have a wonderful rest of your evening, and good night.
And thank you,
Thank you.
Michael.
Thank
Good
Good night,
night.
everybody.
Thanks all.
Thank you.